Letter from the Supreme Court. In these circumstances, it seems clear to me that it is not my duty to remain on the court, but rather to resign in the hope that this will enable the court to proceed with its vital work free from extraneous stress. That is the letter that Clarence Thomas should be writing to Chief Justice John Roberts tonight. Indeed, to follow Supreme Court precedent, Clarence Thomas should have written that resignation letter years ago, because he has been in violation of judicial ethics for many years, and we now know he has been in violation of federal law since 2014, when he refused to follow the law requiring disclosure of the sale of real estate that he owned in Georgia to Clarence Thomas's favorite right-wing billionaire, Harlan Crow, who has also showered several $100,000 worth of private jet travel and yacht travel that we know about, along with other perks, on Justice Thomas, without Justice Thomas ever disclosing those gifts. Harlan Crow has directly put money in Clarence Thomas's pocket in as many ways as he could find, including by buying real estate from Clarence Thomas and by contributing $500,000 to a nonprofit organization that then paid Clarence Thomas's wife a salary of $120,000. You can do the math on that. Clarence Thomas's wife's salary was funded out of a pot of gold that included $500,000 from right-wing billionaire Harlan Crow, and Clarence Thomas for years filed disclosure forms in which he said, falsely, that his wife's income was zero. In these circumstances, it seems clear to me that it is not my duty to remain on the court, but rather to resign in the hope that this will enable the court to proceed with the vital work free from extraneous stress. That was written by Supreme Court Justice Abe Fortas in his 1969 letter of resignation from the Supreme Court because he had subjected the court to not quite 2 weeks of controversy about $20,000 that he had received from a foundation 3 years earlier in his first year on the Supreme Court. The $20,000 was a perfectly legal form of income to a Supreme Court justice at that time, when there were absolutely no laws about justices disclosing anything about their income. Abe Fortas told the story of the $20,000 in his detailed resignation letter. In January 1966, I received a check for $20,000 under the agreement and began my association with the foundation. Later, in June 1966, I reached a decision that the continuing role in the foundation's work, which our agreement contemplated, should be terminated. There were 2 reasons for this decision. My work for the court was much heavier than I had anticipated. I had also learned shortly before informing the foundation of my decision to terminate the agreement that the SEC had referred Mr. Wolfson's file to the Department of Justice for consideration as to criminal prosecution. Mr. Wolfson was the founder of the foundation that paid Abe Fortas $20,000. So Justice Fortas received the $20,000 check. 6 months later, decided to end the arrangement, and then later he returned to the foundation the $20,000. That's it. That's the whole story. In his resignation letter, Justice Fortas said, I have not interceded or taken part in any legal, administrative, or judicial matter affecting Mr. Wolfson or anyone associated with him, and no one ever suggested that Abe Fortas's integrity was ever compromised on any vote that he ever cast on the Supreme Court. That was the entire controversy. He took $20,000, which was perfectly legal to do at the time, from a foundation of someone who later found himself in serious legal trouble, and Abe Fortas immediately backed out of the agreement, returned the $20,000. That's the whole story. And when that story came out in 1969, Democrats and Republicans immediately called on Abe Fortas to resign from the Supreme Court. Now, let me repeat that. Democrats and Republicans called for Abe Fortas to resign from the Supreme Court. Both parties then believed in imposing the same ethical standards of the Supreme Court, no matter which party was involved. And one party had a tremendous amount to gain by Abe Fortas's resignation. Abe Fortas was appointed to the court by Democratic President Lyndon Johnson, and when he resigned, Republican Richard Nixon was president of the United States. And Abe Fortas's resignation enabled Richard Nixon to remake the Supreme Court from a liberal-leaning Supreme Court to a conservative-leaning Supreme Court. The Democrats who called on Abe Fortas to resign from the Supreme Court knew that Republican Richard Nixon would get to replace him, but they still demanded his resignation. This guy was the first Democratic senator to demand Abe Fortas resign from the Supreme Court. He went on to serve as Jimmy Carter's vice president and then the Democratic nominee for president in 1984, who lost 49 states to Ronald Reagan. It never crossed Senator Walter Mondale's mind that Abe Fortas should not resign because there is a Republican president. The Democratic-controlled House of Representatives was threatening to impeach the Supreme Court justice appointed by the Democratic president because of that $20,000 that Abe Fortas received and returned. Abe Fortas did nothing compared to what Clarence Thomas has done. Nothing. In his resignation letter, Abe Fortas said, "There has been no wrongdoing on my part. There has been no default in the performance of my judicial duties in accordance with the high standards of the office I hold." And absolutely no one anywhere offered a shred of evidence to contradict that. Nothing to suggest that Abe Fortas did not perform his judicial duties in accordance with the high standards of the office that he held. Abe Fortas went on to say something that Clarence Thomas, who has been shown to have violated federal law, could never believe what Abe Fortas believed about the Supreme Court. So far as I am concerned, the welfare and maximum effectiveness of the court to perform its critical role in our system of government are factors that are paramount to all others. It is this consideration that prompts my resignation, which I hope, by terminating the public controversy, will permit the court to proceed with its work without the harassment of debate concerning one of its members. Clarence Thomas is prepared to put the Supreme Court and the country through the harassment of unending debate about Clarence Thomas's massive and repeated ethical failures and violations of law and the Supreme Court's general ethical failure. The chairman of the Senate Judiciary Committee, Richard Durbin, wrote a letter of invitation to Chief Justice John Roberts today, inviting him to testify at a public hearing regarding the ethical rules that govern the justices of the Supreme Court and potential reforms to those rules. The last time John Roberts revealed any of his thinking about this subject was in writing 12 years ago. Chief Justice Roberts has been absolutely silent during a period when the ethical standards of the Supreme Court have been publicly questioned more vigorously than at any point in the Supreme Court's history. On the last day of 2011, the Chief Justice issued his annual year-end report on the federal judiciary, and he included a few lines about ethical standards, which may have seemed not unreasonable at the time, but through the lens that investigative reporting has given us on Clarence Thomas now seems downright childish. The Chief Justice wrote, "All members of the court do, in fact, consult the code of conduct in assessing their ethical obligations. In this way, the code plays the same role for the justices as it does for other judges." That is not true. Other federal judges are bound by the code of conduct. The Supreme Court justices are not bound by the code of conduct. So to say that they consult the code of conduct is in every important sense meaningless. Then the Chief Justice went on to say something that we know is absolutely false. Every justice seeks to follow high ethical standards. That is not true. We know beyond a reasonable doubt that Clarence Thomas absolutely does not seek to follow high ethical standards. Clarence Thomas's personal code of conduct appears to be to follow the lowest possible ethical standards that he can get away with. And then Chief Justice Roberts wrote a line that he would not dare try to get away with today. The court has had no reason to adopt the Code of Conduct as its definitive source of ethical guidance. Clarence Thomas has now given the court every reason to adopt the Code of Ethics, which the Supreme Court absolutely continues to refuse to adopt. One of Chief Justice Roberts' principal reasons for why the Supreme Court doesn't need any ethical rules whatsoever was this line written in his 2011 report. The justices filed the same financial disclosure reports as other federal judges. Those reports disclose, among other things, the justices' non-governmental income, investments, liabilities, gifts, and reimbursements from third parties. Yes, the justices file financial disclosure reports. And yes, Clarence Thomas files financial disclosure reports that are not true. Justice Thomas refuses to include information that is required by law to be included, like the sale of real estate. To our knowledge, that has never happened before in the history of the Supreme Court financial disclosure reports. Senate Judiciary Committee Chairman Dick Durbin promises Chief Justice Roberts that if he shows up for the hearing, the questioning will be limited to Supreme Court ethics. That's not exactly reassuring for the Chief Justice. In that hearing, it would be very likely that questions about activity of Clarence Thomas's wife would come up. If the senators were being thorough, and there's no guarantee that they would be on this point, they would also ask a few questions about the Chief Justice's wife. Jane Roberts, who is a very high-paid lawyer, works at a firm that describes her as a high-end legal recruiter with 20 years experience as a practicing attorney and law firm talent developer, one of Washington's most insightful and experienced legal recruiters. Jane advises high-profile law firm partners and groups on lateral moves. So, Jane Roberts doesn't work for one law firm. She works for maybe every high-powered law firm in Washington and possibly even the country in finding lawyers for them. And the lawyers in those law firms appear before her husband at the Supreme Court. It is possible lawyers recruited into their jobs by Jane Roberts, for which Jane Roberts was paid a lot of money, appear arguing cases before her husband at the United States Supreme Court. Now, I am sure that Jane Roberts feels the way Abe Fortas felt, and that Chief Justice Roberts feels the way Abe Fortas felt when Abe Fortas said in his resignation letter, "There has been no wrongdoing on my part." Abe Fortas resigned because of the possible appearance of impropriety, not because he actually did anything wrong. Jane Roberts' work invites the appearance of impropriety. But it is because the work is done quietly and invisibly, unlike Ginny Thomas's mad rantings to Donald Trump's White House chief of staff, which have become public thanks to the subpoena power of the January 6th committee. Establishment Washington is untroubled by Jane Roberts deriving income from more law firms than we could ever count. There is a model of propriety for spouses of people who find themselves in positions requiring the highest ethical standards. The leading model, the best one we have ever seen for how to handle this, is the very first man in history to be married to the Vice President of the United States. Attorney Doug Emhoff was a very highly paid, high-powered lawyer in Los Angeles in a huge corporate law firm with offices around the world. He worked primarily on entertainment matters that in no way interacted with the governing decisions of the White House. But not because he was ever going to be in a position to do anything wrong, but purely out of respect for the importance of the clarity of ethical standards, Doug Emhoff resigned from his law firm. He quit. He took a huge pay cut because he didn't want something done by some lawyer he never met in the London office of that law firm to ever suggest some possibility of a conflict of interest with White House policy. And so Doug Emhoff is now Professor Emhoff. He teaches at a law school in Washington, D.C. That's the model. That's the perfect model. Zero possibility of conflict of interest. Zero. The wife of the Chief Justice could do the same thing. Law schools in and around Washington, D.C. would love to have her, but they won't pay as much as the corporate law firms that put money into the Chief Justice's wife's income. Washington is so willing and so hardwired to accept that kind of appearance that no one in Washington has ever been even slightly concerned or questioned what the Chief Justice's wife does for a living. And this is very important. It is very likely, it is my personal belief, certainly, that no member of the Senate Judiciary Committee would raise that question with the Chief Justice if he were to show up for the hearing. And I also want to stress that I personally believe that the Chief Justice, John Roberts, has never been compromised in any way by his wife's work. I think that is the likelihood. Chief Justice Roberts, disagree with him as you might, does appears to me anyway, to be the kind of traditional member of the Supreme Court who would know exactly how to seal himself off ethically from his wife's work. Clarence Thomas, on the other hand, is the single most outrageous public violator of the ethical norms of the Supreme Court that the country has ever seen in our history. Think about how outrageous Clarence Thomas's conduct had to be to get this attention. Clarence Thomas never knew where the line was. The only way for Clarence Thomas to find out where that line was to just keep going, was to just keep pushing the dollar up, 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 the dollar numbers just up, and to keep flying on Harlan Crow's private jet and to keep sailing on his yacht until Clarence Thomas found the line and crossed the line. In his resignation letter, Justice Fortas said, "It is my opinion that the public controversy relating to my association with the foundation is likely to continue and adversely affect the work and position of the court, absent my resignation." Abe Fortas resigned from the Supreme Court because he thought the controversy about him would adversely affect the work and position of the court. Clarence Thomas has proven that he is not even slightly concerned about how his ethics violations adversely affect the work and position of the court.